The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you. Good morning. The next case is Z.J.W, and we'll hear from the appellant.
Good morning, Chief Justice and Associate Justices. May it please the court. My name is Garen Michael of the New Hanover County Bar, and I represent the father in this case, Scott Arias. At this time, I'd like to reserve 10 minutes of rebuttal, if I may. I'd also like to say thank you for the opportunity to be before you again to discuss another important matter. This case involves the termination of my client's parental rights as to his daughter, Jill. The issues today are whether the trial court erred in concluding that grounds existed to terminate my client's parental rights, specifically regarding the grounds of willful abandonment and neglect. Also, whether the trial court abused its discretion in finding the termination of parental rights was in Jill's best interest. I'm asking this court to vacate the trial court's termination order. As it stands at this time, the trial court termination order it's permitted an unjust reality where the same actions by my client over contemporaneous time periods has resulted in two violently disparate outcomes across two counties. One in Buncombe County that ended in the return of full custody to Mr. Arias of his son, Stephen. The other, just 3 weeks later, in Nash County, which ended in his daughter being permanently taken away from him through the termination order, which is at issue today. I believe the primary point of emphasis and consideration in this case, at least initially, is the ground of willful abandonment pursuant to 178A20-1. I'm going to address that first, as previously adopted by this court. The term and period for adjudicating willful abandonment is the 6 consecutive months preceding the filing of the termination petition. Here, that period would be August of 2018, February 2019. In that time frame, looking at a period where Mr. Arias had been diligently working in Buncombe County DSS, who had custody of his son. Juvenile court in Buncombe County had already found that Mr. Arias had completed all recommendations of the court and DSS as early as August 15, 2018. And again, made that same finding during its September 26, 2018 period. Given that up to that point in time, Mr. Arias' Nash County plan was simply to, quote unquote, work with Buncombe County Department of Social Services and complete their court order recommendations and service plan. By all accounts, based on this, during this relevant period, Mr. Arias completed case plans for both Buncombe and Nash County. Now, admittedly, Mr. Arias did not have any contact with his daughter during this period. However, it's essential to note the fact that he had been precluded from not only visitations, but from all contact with his daughter by order of the Nash County Juvenile Court. Now, this was not an order made by a separate court or I think under Chapter 50, a custody order or anything like that that would have been in place for a period of time. And then Mr. Arias simply never bothered to motion it back for modification. This was an order by the very court whose termination order we are now analyzing. Moreover, the order also precluded Mr. Arias from even being able to effectuate a modification because it relegated the decision of any future contact to Jill's therapist. Now, underscoring this circumstance is the fact that for the entire determinative period, the therapist that Jill was treating with, Annie Shaw, was never even evaluating the appropriateness of visits between Mr. Arias and his daughter. Essentially, Jill's therapist was waiting on Nash County Juvenile Court to tell her when Jill could have contact with her father. And at the same time, Nash County Juvenile Court was waiting on the therapist to tell it the same thing. So all the while, DSS never bothers to inquire with Ms. Shaw on this vital issue of visitation and contact and claim to have no clue until Ms. Shaw comes to court in June of 2019, some 4 months after the TPR was filed and mere days before the termination hearing. And still, Ms. Shaw at that court date refused to even offer an opinion about visitation. She wouldn't state whether contact with Mr. Arias was either helpful or harmful to Jill. Despite being precluded from contact, Mr. Arias did send emails to the maternal aunt who had placement of Jill during this period of time. These emails were sent at minimum at least monthly. The maternal aunt, on her own accord, never initiated any contact, never provided any additional responses beyond direct responses to Mr. Arias's emails, and the information provided was very limited, often omitting important and useful details that should have been included to help Mr. Arias understand exactly what was going on in Jill's life at that point in time, what had happened at school that day, what she was dealing with, things of that nature. None of that was included. The information was very short, very curt. And more importantly, during this period of time, we also have Mr. Arias unforeseeably experiencing very significant medical issues, which caused him to have seizures which were not predictable, and ultimately resulted in having to have multiple operations, including open heart surgery, which required not 4 or 5 days in the hospital, but a stay of 45 days, obviously requiring a very lengthy recovery to get back to full health. Still during this time period, we also had child support, which began being paid in January of 2019. And that continued all the way through the TPR. Though still looking at the determined 6-month period, we also have attendance by Mr. Arias at a CFT meeting, also in the midst of his medical recovery.
Is all of this that you're referring to within the relevant 6-month period?
That's correct, Justice. At this point in time, other than my comment about the child support being paid up to the TPR, everything else I stated in this brief portion has been specific to the determinative 6-month period. That's how I wanted to start, and I'm going to now transition into some of the outside of the 6-month points, if I could.
Certainly, but well, go ahead. I may have some follow-up on that in terms of what you may say about what's outside the 6-month period, but you want to make sure that we understand that there is contact within the relevant 6-month period that you contend would be sufficient so as to obviate any proof of abandonment. Is that right?
Well, it would not be physical contact during that 6-month period, as it was specifically ordered by the juvenile court that he not have any kind of contact at that point in time. So he was unable to have physical contact as a result of that court order. However, he was taking other measures to put himself in the best possible position to parent Jill going forward by complying with his case plan and corresponding with maternal aunt, and of course, getting through his recovery, still attending the CFT, child support. Those are things that occurred within the determined 6-month period.
All right. Maybe you just answered my question, Mr. Michael, but can you give me in a bullet point fashion, 1, 2, 3, 4, what you say your client did during the relevant 6-month period that precluded a finding of abandonment?
During that period, there was obviously the emails that he was sending to the maternal aunt to get updates on Jill, to try to maintain some level of contact. And unfortunately, those weren't particularly fruitful for him, but he still pursued them.
How many were there?
I believe there were, the numbers that were testified to, it was exactly 6 during that period.
Okay.
Some before, some after, but during the relevant period, we're talking about 6.
All right. Emails is number 1. What's number 2?
The child support was being paid began in January of 2019, so that was established and paid in the relevant period. Mr. Arias,
and that, as I understood, it was being withheld from his SSI.
That is correct, Justice.
Okay, thank you. Number 3.
Also, he attended a CFT for his daughter.
In person or on the phone?
I believe that was attended by phone.
Okay.
And so those are the main contacts when asked the court to take consideration the fact that during that period he spent 45 days in the hospital and also had a post-recovery period that was extensive, about a 2 to 3 month period where he was unable to really provide much self-care. Now,
you've couched this. Oh, I'm sorry, Justice Earls. Go ahead.
Go ahead.
I'll get out your way real quick. Thank you. I've heard you couch this in terms of the physical disability that your client had. Are you conceding that but for the physical disability that he experienced, that this personal interaction would be grounds potentially for abandonment?
I would say that I don't think there's any basis for defining grounds for abandonment, especially during this period of time, because he was actively involved with the court and actively involved with Buncombe County, complying with the case plan. I think that his physical limitations as a result of his medical condition, it just underscores the what he had to go through to be able to accomplish what he did, all the while, like I say, working cases in both counties, and attending to his emails, despite, again, an extended stay in the hospital and a recovery period where, I mean, he admitted he basically couldn't handle going to the bathroom by himself. It was that detrimental to, to his ability to function at that point in time.
So your position is that, as I'm hearing it, that he was doing this in spite of his physical limitations, and you're not saying that he didn't do more because it was an excuse that he had the physical limitations.
I would say it's a little bit of both. I would say he overcame these physical limitations to do what he did do, but for them, he could have done even more potentially. It's impossible to say without having to deal with what we have, the facts in front of us. It's hypothetical, but I certainly believe he could have possibly done more if he hadn't had to spend the extended time in the hospital. So I do think that curtailed his ability to some extent, but nevertheless, efforts were made, and his efforts, I think that sort of the next part of my argument sort of feeds into what he did during that 6-month period and what that accomplished thereafter for Buncombe County and his son.
Okay. Thanks, Justice Earls.
I just want to clarify 2 quick things. During this 6-month period, is this a period of time, in addition to being in the hospital for 45 days and then recuperating at home, is it also true he did not have a car?
Transportation, it was a documented issue throughout that point in time, as well as a valid driver's license. So I mean, those were potential barriers, absolutely.
And he lived in Asheville, and Jill was in Nash County.
Right. All relevant times he resided in Buncombe County, and Jill was in Nash County. That's correct.
And just one other factual question. The 2 letters that he wrote, that were I think one of them was read to her. Did that happen outside the 6-month period or during the 6 months?
The one that was read to her would have been read in April, which would fall outside of the 6-month period. It would have been about 2 months after the 6-month period would have been.
Thank you.
So that sort of leads me into, if we start looking at the outside of the determined 6-month period, I think we have to consider what Justice Earls just asked about, actually, with Mr. Earls taking advantage of the first opportunity he actually had when he was afforded by the court in April of 2019 to have contact with his daughter, and he promptly wrote a letter. He did it thoughtfully, very carefully. It was read in its entirety into the record. It's found at page 111 through 113 of the transcript. It was very appropriate. It was found to be appropriate by Jill's therapist. Jill's therapist did read that to her. Obviously, Jill had a negative reaction to it. However, her reaction was that it made her feel icky and that it reminded her of the other one, which brings us to how Jill came into custody in the first place in Nash County, which is one of the most tragic parts of this whole case, is that when Jill was residing out with her mother and not with Mr. Arias, she was also residing with her mother's husband, who perpetuated sexual assault on Jill, and was under the watch of Mrs. Wells, her mother, who knew about it and did not take immediate action to protect her daughter. And so that's the dark cloud that hung over this case as it opened in Nash County, and custody non-secure custody was taken in Nash County. I also think we have to consider that Mr. Arias in Buncombe County, his Buncombe County case, although again it falls outside the 6-month period, he got trial home placement of Stephen in May of 2019, and custody returned and his case closed in July of 2019. So he's only about 3 months removed from that medical recovery period, and he already gets trial home placement in Buncombe County due to his case compliance. And then 2 months later, less than 2 months later, actually, custody is returned and the case is closed. So Buncombe County has determined that his home is safe and appropriate for Stephen to return, and then after a period of time of monitoring it, finds that it's appropriate to return custody and close his case. And this happens in the same month that Nash County finds it, Nash County Juvenile Court finds it appropriate to terminate his criminal rights to Jill. I would also say you have to consider the circumstances under which respondent mother, if we want to look back, as I know Department of Services wants to look at, and the Guardian wants to look at what happened before the Nash County case started, going back to when Ms. Wells abruptly abandoned Mr. Arias and her own 4-year-old son, Stephen, and the efforts that she took when she left to make sure that Mr. Arias had no way of getting back into Jill's life, or no easy way of getting back into her life. For instance, she never returns to the home of where her son lives. She doesn't try to maintain contact with her son. She doesn't call Mr. Arias. She doesn't. She leaves in the only vehicle that they own between them. She changes her number. She changes hers and Jill's last names. She blocks Mr. Arias on social media. I mean, the circumstances that Mr. Arias faced were also significant, that he was thrust into a position to act suddenly as a single parent, trying to provide for a young child who had special needs, including autism, while dealing with his own longstanding condition of Crohn's disease and his own mental health needs, which include depression, anxiety, and agoraphobia. Still, he was able to overcome these. Initially, he also, as was mentioned before, again, the note not having transportation and limited income, as he was receiving disability in connection to his Crohn's disease since 2002. There were efforts made by Mr. Arias. I understand that the Department of the Guardian don't believe he made any reasonable efforts during that time, but he did contact maternal relatives, which was to no avail. There was no assistance provided from them to make contact with Jill. He did consult with potential family law attorneys. However, he was informed that he would have to provide a $5,000 to $10,000 retainer on the front end, money that he simply could not put together during a period of time where he's on a fixed income and trying to take care of Stephen as a single parent.
Mr. Michael, just again, so make sure I'm understanding the record correctly, which is a large part of the game in these cases, that you've been describing a series of instances which you're describing the client as having contacted various attorneys for custody-related purposes. I know your client testified to that. Did the trial court make any findings based on that evidence?
I believe there were findings, yes, that's included in the termination of rights order.
About his efforts to contact attorneys?
Correct. And I believe it also includes the legal aid as well, where he was conflicted out as a result of the prior representation of Ms. Wells by legal aid.
Was there ever a time along the way that your client had a chance to, even though outside the 6-month period, since you've raised some explanations about what's outside the 6-month period, an opportunity to be involved with Jill, and his response was that he was too busy with Stephen to be involved with Jill?
I would say that question, Justice, and I appreciate the question because it's an important note there that he was reached out to by DSS, who was not forthcoming with information as they were in an investigation process, and I don't know that they were truly assessing his ability. And I do think it's understandable for somebody who's dealing with the things that he was to make a comment that when taken out of context could sound like he has no interest in Jill, but in reality it's a statement of honesty that he's doing his best in taking care of a child that has special needs, and that at that point in time he may not be able to do something in that moment. And a lot of times those investigative calls by DSS to a parent who does not have the child, a lot of times they're looking for immediate action. Can you come and get this child now? And I don't think that's what they offered him. But I don't think he was in a position to necessarily do something in that moment. And I think his comment was taken out of context based on the way the comment was made and the way it was interpreted.
Well, in what context would you put it? Are you saying that it was more brusque than or less brusque in terms of his position concerning Jill at that time?
I would say it's probably just an honest statement regarding his level of mandates and requirements for Stephen at that point in time, and what he felt like he was capable of doing at that time. I don't think it's an indication of a lack of desire. I think it's just an honest assessment off the cuff, in that response when he's getting lack of information from DSS. They're not telling him, oh, by the way, she's living here and you can go and visit her anytime you like because there's no order preventing you from doing that. And we'd like to help you, facilitate that visitation and get your relationship back. There was none of that. That was in any evidence presented by DSS indicate that any of those efforts were made to try to integrate him in any way, shape, or form. It seems like it's an investigation, a call. He's potentially at a bad moment where he's dealing with a lot of things with his child, and he makes a comment, and they want to run with it and assume that that's a global comment, where I think it was a very in the moment comment.
Did he leave the door open for his interest to be more active? You've got a chance to get ahead of DSS in terms of what we're hearing on this, and you seem to feel as though you know what's going to be said about it. Is it your position that your client would have been more welcoming, but for the opportunity that he had to take care of at that moment with Stephen?
I would agree with that. Yes, absolutely.
All right.
I have pushed in a little bit to my rebuttal time. I do have a couple other comments, but if there's no other questions right now, I'll go ahead and reserve the remainder if it pleases the court.
Thank you, counsel. We'll hear from the appellee.
Counsel, you're muted. Ms. Norwood, you're muted.
Good morning, Chief Justice Newby and Honorable Associate Justices. My name is Jane Norwood. I'm the attorney for Nash County Department of Social Services, the appellee in this matter. Ms. Mackey, the attorney for the guardian ad litem, and I are going to split our time, each using 15 minutes. I will devote my 15 minutes to addressing the issue of abandonment. Ms. Mackey will address the issue of neglect and best interest. If it please the court, I have three main points with regard to addressing the issues. One, the credibility of Mr. Arias with our trial judge. Two, the abandonment case, and abandonment as it particularly pertains to this case. And three, the ability in abandonment cases to look outside of the relevant 6-month period. First of all, with regard to credibility, I think it's fairly obvious from the transcript and from our judge's order that she and our judge, as we know, in a case without a jury, the judge who is having the opportunity to hear testimony and to observe the demeanor is considered to be in the best position to make determinations with regard to credibility. I think it's fairly clear in the rendering of the oral rendering of her judgment and the transcript on both the best interest phase and on the grounds phase, that our judge simply did not find that Mr. Arias had, I'm not sure she believed what efforts he had made to maintain contact with Jill, that she felt that he could have done more. What he offered the case.
Is the question for purposes of abandonment more could have been done, or whether what was done was adequate?
I think she thought he could have done more, and I think that she thought that what he had done was inadequate, and that then in light of the entire picture, it was hard to look at the part that he did during the 6-month period in light of a lifetime or multiple years of not trying to have contact with Jill. I think she found that his whole entire testimony to be not credible. With regard to the abandonment case, I think, first of all, for all intents and purposes, Mr. Arias came into this case as a stranger. He came in, Jill, there was evidence in the record that Jill had said that she did not remember the time that she had resided with her father at a hearing. She didn't remember him. He was a stranger. And he came into our case not only as an innocent stranger to the child, he came in as having lost custody to another Department of Social Services of the one child that he was raising. He came in having to himself complete a psychosexual evaluation. And on our end, here we have Jill, who admittedly not sexually abused by her biological father. She had been horribly sexually abused by the person that she saw as her father figure. And so it wasn't just, we weren't in a position where we could take this stranger who is now, who we established paternity for, who had not established paternity of Jill at age, I believe she was at 9 or 10. He had not established paternity of her or of Stephen. He hadn't established paternity of either of his children. Both Department of Social Services did that within the context of filing the petition. And then we can't just look at, okay, now he's the father and this child doesn't know him. And just because he's the father, we're going to have to all of a sudden start inserting him into visitation. We had to do that at a speed that we felt that was in Jill's best interest. The way that we did that, number one, it was very complicating, and it's the only case I've ever had where we had a child that was already moved halfway across the state, working with another Department of Social Services, and it would have been impossible for our agency to say, well, he is the father, we've established he's the father of Buncombe County, can Jill come there and live? Of course Jill couldn't come there and live when we first got involved in the case because he didn't have his own child. His own child was in therapeutic care. He had been deemed to have been homeschooled without the proper authority, without the proper backup paperwork. He had been deemed to have smoked marijuana or to have been exposed to marijuana at a very young age. And that was not a home that at the very beginning we were going to be able to place Jill in. And we had to look at Jill's best interest somewhat. And so our way to address that was to say to Mr. Arias, you've got to get on board. He came into this case sort of behind. You'll notice that at the very first, at the underlying adjudication and disposition, our primary plan was reunification, but our secondary plan was adoption. We knew in our mind that there was almost nothing that Amy Wells could do that would convince us that Amy Wells's permanent rights did not need to be terminated. We were willing to work with her on reunification, largely because we knew we were going to have to work with Mr. Wells on reunification. We asked him to complete the case plan in Buncombe County. We needed for him to get on board immediately and do that. And in the meantime, we offered the opportunity for him to at least to show some interest in Jill by way of emailing her aunt. The record shows that he was provided the means to do that for the first time in July of 2018. He lost the contact information. He was provided the contact information to the aunt in August of 2018. He lost that information. And finally, for the first time in September of 2018, did he make the first contact. He admitted on the record that part of the reason that he did not, it wasn't just that he lost the information, it was that he and the aunt had bad blood. He let that interfere with admittedly, it was a tiny door, but it was the tiny door to open to have some sort of contact and see how Jill was doing. It was a door, and it wasn't a formal no contact order. It was contact through her aunt, which at that time we thought was best for Jill. He delayed in having his psychosexual evaluation. He didn't like the type of therapy that Buncombe County was asking him to do. He resisted that type of therapy and did not do that until later. He was ordered not to have his mother in his home. He admittedly, he's probably one of the most sympathetic, in my view. I do have a heart. he is one of the most sympathetic, respondent parents that I've ever seen, because he's agoraphobic, he had mental health illnesses, he was raising an autistic child. I understand all of those barriers, and at the same time, he had a medical situation where he could not take care of himself. But he chose to take care of himself in a way that violated the Buncombe County order. He admits that he was told by Buncombe County, if you let your mother move back in your home, then you are slowing down the progress of us being able to get Stephen back in your home. He did that anyway. There was testimony that he had a sister, that his sister he could have come to live with his sister. We heard testimony that he was receiving SSI. That would mean he probably had Medicaid. He could have gone to a rehabilitation facility to recover. It didn't have to be in a way that was violating the order. Even if he was violating the order, if he was going to do that anyway, all we were asking him to do was send emails. And if you open that door just a little bit, then why couldn't he, every single day he was laying in that bed, dictate an email to his mother, or his mother to send to Jill to say, yes, yes, Judge, yes, 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 yes to anybody who's looking. I'm going to do every single thing that I can do to make sure that this court knows that I'm interested in my child. And we don't believe that he did that. I know that his 6-month time, moving on to looking outside of the 6-month period, I know that it doesn't seem to me a lot of times that the court likes to look out of the 6-month period. But I think that what our judge looked at and what we were looking at is a lifetime of, if he could have come into our case, at least having had some relationship with Jill, or if he could come into our case having had a son that he had successfully parented, we could have asked Buncombe County, hey, can you do a home study on Mr. Arias and see if we can look at sending Jill to Buncombe County, and we couldn't do that because he didn't know Jill. Jill didn't know him. And we do have to consider her feelings. I know the minute that we established paternity, he had constitutional rights. He became a father. He became a parent. But he became a parent that his child did not remember living with a parent who had lost custody of his other child. And I think this is a very fact-driven case. And so we needed for him to do everything right during that 6-month period. And we don't think he did. We think that there was more that he could have done. And when you look at the whole body of the case, we're supposed to take a sexually abused little child who doesn't remember her father and say that because in 6 months he didn't get Stephen back within the 6-month period. He actually got Stephen back on a trial placement. I think the PPR lasted over a 2-day period, and during in between the first day and the second day period, he got full custody back of Stephen. That wasn't within the 6-month period.
Are you urging this court to look outside the statutory 6-month period to ruling in favor of DSS and the guardian ad litem?
I am asking that. In the NDA does say that although I understand that although the court must look at the 6-month period, you can look outside the 6-month period to determine credibility and intent. And I think when your intent has shown that for the majority of this child's life, he abandoned the child, he focused on, as he said, I've got my hands full of Stephen. And if Buncombe County were asking for mother to parent Stephen, I would say the same thing about mother. You don't split your children up and parent one and then parent the other and totally disconnect contact between the 2 children. And with Jill's case in particular, this child had been horribly traumatized. And he didn't come, he came to a phone hearing for the adjudication. He came to, I think, 4 hearings in person, and 2 of those were the termination of parental rights hearings. We provided him transportation, at least 1-day transportation to come to hearings. We had the CFTs over the phone. He didn't even come to all of the CFTs. He admittedly, he had some emotions because he was trying to. I think there was one hearing when he did come, and he anticipated that we were going to address visitation at that hearing, and it didn't happen. And so after then, there was a CFT, and he didn't participate in the CFT. He was disappointed about the issue of visitation. And
Ms. Norwood, I just would like to follow up on one comment you made about the fact that in order to show that he had not abandoned his child, you needed him to do everything right during the 6-month period. And I'm just wondering what the record shows in terms of what notice he had, that 6 emails during that period wouldn't be sufficient to demonstrate he hadn't abandoned his daughter, that you expected him to send an email every day. Did he have notice that that was what he was required to do?
No, ma'am, I can't say that we were specific with regard that he needed to do it every day. But I guess I would just think that if he had an attorney, he actually had 2 attorneys. He had an attorney in Buncombe County and he had an attorney in Nash County. And that if he were really honest about showing, he knew a lot of time had been spent talking about the total lack of contact that he had with the child until we drew him into the DSS matter in Nash County. And I wouldn't have think he needed to be told if he were honest about what can I do, and if the only thing they were going to let me do is email her. There was testimony that he did email the aunt and asked what size she wore, what kind of clothes she liked, and then he never sent anything. So I just think, although limited, when your time is, what you can do is limited, you do it to the very best of your ability that you can do. And we, of course, Ms. Mackey is going to talk more about the neglecting of that. And but with regard to abandonment, our court at least felt that his failure to make the very most of the avenues that we were giving him to comply with the order in a timely manner, to comply with the order in Buncombe County, and to comply with what he could do in our case, that he needed to do it, and he didn't succeed. And I think the court.
Ms. Norwood, is it your contention that the respondent would have abandoned the child in the event that he didn't do everything that you've asked? You being the DSS?
I think in this particular fact scenario, given the fact that he entered as a stranger, that he needed to show that whatever avenue we were giving him to develop, keeping in mind we had to consider this child's feelings too. So we had a very narrow set of circumstances of what we thought he needed to do, and at that point, all we were saying was do email, and that's a
so is the answer to my question essentially yes? Did in your view he had to have done everything you asked him to do in order to avoid being found to have abandoned the child?
I think he did. And I also think he's afforded another opportunity in the letter, and he wrote the letter, and I'm not taking away from that. He wrote the letter was appropriate, but we also have to consider that the impact of that letter on the little girl. She got the letter, and she felt icky it reminded her of the other one, and that is not Mr. Idris's fault, but it's a fact of the case that impacted the way we proceeded with the case.
All right, thank you.
And that's, I'm through.
Thank you, Mr. Chief Justice and Associate Justices, and may it please the court. My name is Caroline Mackey, and I represent the guardian ad litem. I will focus my argument today on the trial court's adjudication on the ground of neglect and the best interest of the minor child. As the court is aware, if the determination of abandonment is supported by sufficient findings and evidence, then the court need not reach this additional ground of neglect. But here, the trial court also properly concluded that the respondent father neglected Jill, and that was based on findings that were supported by clear, cogent, and convincing evidence. Under 7B-10115, a neglected juvenile is one whose parent does not provide proper care, supervision, or discipline, or a juvenile who lives in an environment injurious to the minor's welfare, or a juvenile who has been abandoned. Neglect based on abandonment is found where a parent's conduct demonstrates a refusal to perform the natural and legal obligations of parental care and support. Here, respondent father.
Ms. Mackey, is it your contention that the only basis for a finding of neglect here is neglect by abandonment?
No, Your Honor. I think neglect based on abandonment is one ground, but he also failed to provide any care or supervision at all to the minor child. So you can look at that and the past neglect and the possibility of future neglect based on that ground.
Okay, thank you.
And to that point, when a minor has been out of the parent's care for a long period of time, the court has to look at past neglect and the likelihood of future neglect. And that requires consideration of changed circumstances. The focus in all of this, of course, is on the circumstances surrounding the child, not the fault of the parent. Here, while the father did not have any role in the severe sexual abuse that Jill suffered, his absence from her life cannot be used as a sword to prevent the termination. As the trial court observed, she had no relationship with her father at all. He had not seen or talked to her in at least 6 years before the petition to terminate his parental rights was filed. She was 3 years old when he last saw her, and she was 9 when that was filed. He never made an effort to establish paternity until Nash County DSS arranged it. When he learned that Jill was removed from her mother's home, he did not ask any questions. He never tried to find her. He didn't ask who was taking care of her or where she was. He said he could not remember the last time he had seen her. And the reason he didn't ask any questions, there were 2 reasons that he gave. First, he said his hands were full with his son, who was in custody of Buncombe County DSS at the time. And second, he says DSS told him it was confidential. And this is important. It was confidential because his name was not on Jill's birth certificate, because he and Jill's mother had domestic violence protective orders against one another at the time. It was also confidential because he was not an active and involved parent, and his paternity had not been established. So without being certain of his paternity, DSS was limited in what they could tell him. But there was also testimony in the record that if he had asked, DSS would have at least told him where Jill was, but he didn't ask. All of these facts point to his neglect of Jill. By June of 2018, he knew all of the details of the sexual abuse as to Jill because he had heard all of the evidence read into the record at the adjudication hearing. But despite hearing about that, and despite the 6 years that had lapsed since he had seen his daughter, he didn't even send an email until 2 months later. And he said that he lost the email address twice. The trial court found that even though he knew about the sexual abuse, he made no efforts to check on Jill. And this finding is supported by the evidence and has gone unchallenged. Our courts have held that a parent will not be excused from showing interest in his child's welfare by whatever means possible. And here, as my co-counsel has described, respondent father could not take custody of Jill because he was involved in his own case at the time due to some issues that were sexual in nature there. He was ordered to do a psychosexual evaluation. And after that, a boundaries agreement was put in place with Stephen that prevented things like co-sleeping. It suggested closing doors when they were changing clothes and other red flags that came up in that evaluation. Jill was the victim of horrific sexual abuse. And as the guardian ad litem noted to the trial court, this case may be as bad as it gets for a surviving child of abuse. And respondent father was not part of her life and was not a support system for her. Given her need for ongoing therapy and his own precarious situation, the trial court did not err in finding that neglect would continue if she were placed in his care. And the trial court properly made that determination.
Is there an indication in the record that there was inappropriate contact upon a meeting with the biological brother and with Jill?
There was. The biological brother came over Thanksgiving for visitation, and there was evidence in the records of him exposing himself to the other children in the house. And that was just an additional red flag in this, and particularly in light of the severe sexual trauma that Jill has faced.
I have another question about the record, and I'm not sure if this goes to best interest, but am I correct that the likelihood of adoption is by the aunt, so the maternal aunt, and that during the course of this case, Jill's mother, biological mother, has continued to visit with her while she's in the custody of her, essentially with her sister? Jill's with her mom's sister?
Yes.
And so that would likely, and the mother was also convicted of obstruction of justice by hiding the sexual assault that happened.
I believe that's correct.
And so then is following this termination, the mother, the biological mother, would continue, even with the adoption, would continue to be visiting with Jill?
Yes, Your Honor. What I understand from the record is that there were supervised visits with the mother and the aunts, and that I don't know what the future would hold for those, but the permanent plan, and that does transition me to best interest, if I may. The permanent plan that the court put in place was termination of parental rights so that Jill could be adopted. And what Jill really needed was permanence and protection. And as this court knows, the standard of review on the best interest determination is abuse of discretion. Based on respondent father's memorandum of additional authorities, he didn't get there in his first argument, but I suspect he would like to make the argument that the guardian ad litem should be judicially stopped from making this argument on best interest, because the attorney advocate below suggested to the court that guardianship would be appropriate rather than adoption. But quite simply, this is not a case of judicial estoppel. That was a brief closing argument by the attorney advocate. And the guardian ad litem report that was in the record and that the trial court relied on suggested or asked for adoption as the primary plan and guardianship as the secondary plan. This is also not a case of judicial estoppel when the court has held that a trial court has no obligation to consider other dispositional alternatives, such as guardianship. And that's the case of Z.J.W, a 2019 case. And that case has been affirmed numerous times by this court. In Z.J.W, the father argued that the trial court should have considered guardianship or custody to the foster family, which would leave a legal avenue by which the children can maintain a relationship with their father. And that's precisely what respondent father is arguing here. This court said, we disagree. While the stated policy of the juvenile code is to prevent the unnecessary or inappropriate separation from their parents, we note that the best interest of the juvenile are of paramount consideration by the court. And when it is not in the juvenile's best interest to be returned home, the juvenile will be placed in a safe, permanent home within a reasonable amount of time. So the guardian ad litem could not have argued on appeal that the trial court erred in not ordering guardianship in light of this court statement in Z.J.W that the trial court has no obligation to consider alternative placements. Stated another way, we are not swapping horses on appeal by taking the position that the trial court's disposition here met the best interest of the child. The question is whether the trial court abused its discretion, and there's no requirement that the court must consider whether an alternative plan is available. Indeed, the best interest of Jill here are served by termination, and the trial court properly considered the statutory criteria. Jill does not know her father, and she has no desire to see him. When he sent her a letter, it made her feel icky because it reminded her of her stepfather. Jill is doing well with her aunt and uncle, and they want to adopt her. Her grades have improved. She's involved. She has a bond with them and no bond with her father. The trial court properly considered all of this evidence in deciding that adoption would best serve Jill's interests. And if there are no further questions, then we would ask that the trial court's order be affirmed. Thank you.
If I may, I want to start by initially apologizing, Justice Urban. I made a misstatement in my prior argument to your question about the record containing a finding of fact specific to Mr. Arias. In his efforts to consult with family law attorneys and legal aid, that was a point of emphasis that I contested. That is not specifically in the TPR finding, so I'll make sure that is correct.
Appreciate you doing that. There's so much in these orders. Sometimes it's hard to make sure you see things, and that's why I ask a lot of the questions that I ask. But I appreciate the clarification. Thank you.
Absolutely, and I appreciate that as well. I think there's a couple more things that need to be pointed out here. Initially, I would indicate that I reiterate my arguments about the abandonment issue. I think that Mr. Arias's actions before the determined 6-month period, but definitely during the determined 6-month period and after, leading up to the termination hearing, I think those actions belie a conclusion that he had any intent to forego his parental duties or claims as to Jill, but I think they're rather indicative of the exact opposite. I mean, in this situation, Ms. Norwood indicated, well, he could have done this or he could have done that. Well, unfortunately, that wasn't in the court's order. The court sort of stayed pat with comply with Buncombe County. That was his court order, comply with Buncombe County. He did just that. He achieved reunification in the same month that his rights were terminated as to Jill. So I don't think his actions in complying completely with Buncombe County custody return is in any way a sign of abandonment, because he was doing what the court told him to do. He was complying with the court order. Beyond that,
it seems to me, Mr. Michael, and the ultimate question here is, am I understanding the law correctly? It's always seemed to me with respect to abandonment that the issue was during the relevant 6-month period, taking into consideration any inferences that can be drawn about intent from other time periods. What did the father in this case do, and was that sufficient to preclude a finding that he, whatever the standard is about failed to provide care and concern and that kind of thing? Is that essentially the right way to look at it analytically?
I would agree. We look at the 6 months, and you look outside of those 6 months to look at the intent. And I think that the recent actions of Mr. Arias speaks to his intent, and that he was doing what he needed to do, and he accomplished a feat that, we as parent defense attorneys, we hope we can get our clients there to unification. And it's a unusual circumstance and very concerning result where you have the actions of one person resulting in two completely opposite results in two different counties. And I think that's really something that has to be looked at with this case. I think that the arguments to abandonment, it speaks to neglect as well. I disagree with the Pele GL's position about neglect and the likelihood of future neglect. I think the fact that he complied with his case plan in Buncombe County and put himself in a position to get custody returned to Stephen, he eliminates any possibility of a likelihood of future neglect. The trauma that she experienced was at the hands of Mr. Wells, and that was facilitated by the mother who took Jill away from Mr. Arias years ago. And then to compare the actions of Mr. Arias and the actions of Ms. Wells is really very disturbing when you think about it, because Mr. Arias never made Stephen unavailable in any way, shape, or form to Mrs. Wells. He didn't take her away. He didn't change his number. He didn't block her on social media. He didn't tell his relatives not to, none of the actions that he didn't change his name. None of these actions taken by Ms. Wells were taken by Mr. Arias with regards to Stephen. So I don't think a comparison of the two is at all remotely fair. I do think that
Mr. Michael, can you address the likelihood of future neglect how in light of the incident that occurred at Thanksgiving with the older brother and Jill?
Well, I think that would be specific to obviously taking a look at sort of the dynamics of what you're dealing with when you're talking about termination of parental rights. I mean, it's not a standard that he has to be able to be in a position to take Jill home that day. There's been no therapy put in place to assist with that transition in any way, shape, or form during the life of the case. I mean, he was basically ignored by the therapist the entire time. I mean, when she got the letter, there was no therapy on the front end of that letter about conversations with Mr. Arias about what he should say or shouldn't say, or any evidence that there was therapy provided to Jill about how to receive that information and how to process it. I mean, there's just nothing there, because the reality is that therapists basically acted like Mr. Arias didn't exist for the entire time the time frame that we're looking at for this case while Nash County was involved and she was in treatment. And I think that's an important factor. And I don't think I think if you look at page 209, you look at findings at least 33 through 35, if I'm remembering correctly. Yes, it's pretty encompassing of abandonment within neglect and the future likelihood of neglect based on abandonment. So if there's no abandonment, I don't believe there could be any future likelihood of neglect, in addition to the actions taken by Mr. Arias in Buncombe County in complying with his case plan and the efforts he did go to maintain contact with his daughter when the court was for no reason preventing him from it, because the court had no basis for preventing that visitation, because the court was under the assumption that the therapist was not recommending it, and the therapist was not doing that. She wasn't even evaluating it. So it's a really unfortunate circumstance, and the reality is grossly disproportionate to the circumstances. Moreover, to jump in a little bit real quick on the guardian's position, I do think there should be more. I don't think it was a brief statement made during closing. I understand it wasn't a long statement, but it's unusual for a guardian advocate to advocate during grounds and cross-examine in favor of termination, and then on best interest to state, well, it's really not fair, and we can achieve permanence and safety short of termination of parental rights. That's not a common occurrence in our juvenile courtrooms. And so I think that is not something to be taken lightly. I think that the arguments made at the trial at the appellate level are an attempt to join the winning team, to get the better mount. I do think that it's akin to what happened in the Court of Appeals case, the Henry IK in 2013. I think it's jumping on the horse. It's riding in the opposite direction. So I disagree with the GL's position on that. With regards to best interest, sort of in general, I think we also, the fact of the matter is that Jill did not have to go home to Mr. Arias for there to be an entry of an order finding that termination is not in her best interest. She could continue to live with her maternal aunt and still have parental rights intact. There's no reason that those two things can't, they can't happen at the same time. It wasn't a requirement. And the result was that we have this disturbing reality that Mr. Arias, who indicated at the initial disposition hearing that he attended by phone, that he wanted to have custody of his daughter, and then follows through with the only case plan that the court ever gives him and achieves reunification in Buncombe County, and he gets his rights terminated, while mom, who perpetuated the most atrocious of things on Jill, we'll still get to have a relationship because the placement provider and potential adoptive person is her relative. I don't believe there was any court findings or basis for that visitation to happen or any indication that that was in any way healthy for Jill. But the aunt made it very clear that she was going to continue to do that going forward. And so I think the result, the difference in the results between the two counties, basically the same act as for Mr. Arias, and this disturbing reality that we have with what's going to happen going forward with Jill. I think that those reasons feed into the best interest and sort of the overarching concerns that I have for this case and where we are. And I'm asking that this court, respectfully asking this court, vacate the termination order, terminate Mr. Arias's priority.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is in recess. God save the state and this honorable court. Thank you, counsel.